So good evening or good afternoon, rather, everyone. Welcome back from the spring break and welcome to the April month's Max Weber lecture. We're very happy to have with us today Professor Fleur Johns from the University of New South Wales in Sydney. And she will be introduced to us by one of our Max Weber fellows, Francisco Jose Quintana. So I'll just leave the floor.
Thank you, Juho, and good afternoon, everyone. It is a great honor for me to welcome to the UI and introduce to this diverse audience our speaker for today's Max Weber program lecture, Professor Fleur Johns. To those of us who are legal scholars, Professor Johns needs no introduction. Her contributions to international legal theory, law and development, and law and technology have consistently been... louder? So I was saying that Professor Johns' contributions to international legal theory, law and technology, and law and development have consistently been at the forefront of new developments and ideas in international legal thought. I still remember attending a lunch lecture by Professor Johns during my first weeks as a master's student in London a long time ago. So Professor Johns gave a lecture on data gathering and the redistribution of the sensible and international and the power to govern international law. And I remember realizing, so this is the kind of powerful thing that one can do with international legal thought. Among her many influential works are the monographs Non-Legality in International Law and Rule in Law, Cambridge University Press 2013, and the more recent Help, actually #Help, Digital Humanitarianism and the Remaking of the International Order, published by OUP last year, which discusses the rise of digital humanitarianism and its implications for international law and politics. Professor Johns is currently professor in the Faculty of Law and Justice at the University of New South Wales, and the floor is yours. Thank you.
Thank you so much, Francisco, for that generous introduction, and thank you, Juho, for the invitation to be here today, and to Veselina Spiridonova for making all the arrangements, and Gabriela Badlik for also the activities we're going to be doing tomorrow with Francisco and Gabby. It's such a pleasure to be back here. It was 9 years ago that I was here on sabbatical with my family, and I fondly remember many conversations with Max Weber fellows during that time. Lots of conversations with PhD students and postdocs here, including Max Weber fellows. So it's really a pleasure to be here and a privilege as well. Now, I understand that there have been, and perhaps are still, several interdisciplinary research clusters ongoing in connection with the Max Weber program, concerned with digital transformation, technological change, transnational democracy, and the crisis of expert authority. And my remarks today are going to touch on all those themes with varying degrees of directness. And I do so in the context of the growing recourse by governments, international organizations, NGOs, and corporations to digital technology in the international humanitarian field. That growing recourse is clearly manifest, but remains highly uneven and patchy. Every international organization today that is dedicated to humanitarian work, and many of their national level counterparts, has an innovation arm dedicated to identifying, developing, testing, and deploying frontier technologies in humanitarian work, by which is typically meant some variants of digital technology. The World Food Programme has a WFP Innovation Accelerator. UNICEF has an Office of Innovation overseeing at least 10 innovation labs worldwide. UNHCR has an innovation service managing 4 innovation funds. The ICRC has an innovation facilitation team. And more than a decade ago, the UN Secretary General established UN Global Pulse with this kind of mandate that now has labs in Indonesia, Uganda, Finland, and the US. So you get the idea. Everywhere you turn, there is some version of this kind of innovation activity ongoing. And the major commercial tech players are heavily invested in digitalizing humanitarian work as well. Microsoft administers a grant program called AI for Humanitarian Action and publicly celebrates its partnerships, that's the language used, with UNICEF, UNHCR, the American Red Cross and others. The Alibaba Foundation has worked with UN Women and the World Food Programme on developing digital humanitarian platforms, one of which I'm going to talk about in a moment. And the same is true of Google, Hewlett-Packard, and many others. And all of these initiatives and the various hackathons, grant programs, competitions that they are running are generating a litany of new tools, websites, mobile applications, sensors, sensor arrays, custom designed or repurposed platforms, software programs, and hardware, all of which are supposed to make humanitarian work more effective, more inclusive, more timely, or otherwise better. So in a moment, as Francisco said, I'm going to advance an argument concerning the ramifications of this shift for international law and politics. But before I get to the guts of this argument, I thought I'd take a few moments to say a little bit about how I approach analysis of these phenomena. And I want to do so by distinguishing my approach to the effects of digitalization's growing ubiquity in international affairs from an instrumental or means-ends rationality. And it seems especially appropriate to do this in the context of a Max Weber lecture, given Weber's well-known critique of the role of instrumental reason in the rise of capitalist rule. So today, I want to resile from instrumentalism in two ways, both by resisting instrumental diagnosis of the effects that digitalization is having on international law and politics, and by abstaining from a project of instrumental redirection that would seek to steer the use of digital technology in the humanitarian field towards some preferable, predetermined, desired end state for society. Now, I won't, as you all hear, necessarily resile from all forms of instrumental reason, but I have misgivings about both these kinds of uses of instrumental reason. Over the past 5 decades, the task of trying to map the field of international legal work, including international legal work of the humanitarian kind, has taken up a lot of scholarly energy. And many modes of reasoning deployed in its analysis vary very widely, but an awful lot of them have been instrumental in some version or another, by which I mean modes of reasoning concerned with how law and legal institutions might most effectively deliver on some predetermined ends, or how they have in fact come to serve particular ends or might serve different ends. The ends to which international law is supposedly an instrumental means may be pernicious ends like racial or class domination. We might worry about international law being a handmaiden to elite rule, for instance, and I do worry about this. Or there may be ends considered desirable, like, say, social protection or some substantive conception of the good life. We might work towards making international law a better servant of these kinds of ends in the hope of making the world a better place. Or we might try to redirect it from one end to another. To some, the best way of finding a pathway through the dark morass of global life is to identify a destination that we seem to have arrived at already, say, entrenched global inequality and climactic precarity, and try to figure out the legal means that may have delivered us there, and then set about to change or try to reverse those to set us on an instrumental path to some other destination. Much excellent work has been done in this mode. But the difficulties with this approach are several. I would like to highlight two. First, between the late 19th and late 20th centuries, as you well know, an array of legal thinkers and practitioners drew attention to the limits of deductive reasoning. They did so on several grounds, For one thing, deductive approaches seem to lead often into deductive error. There are multiple ways that a particular legal decision maker might try to give effect to, say, a broad principle of autonomy. So the deductive process cannot predict any particular outcome without recourse to some other undisclosed priority or preference or investment. So in the wake of this kind of work, it no longer seems feasible to place much confidence in the idea that specific legal rules or case outcomes could simply be deduced from a relatively small number of basic principles, fundamental commitments, or overarching systemic observations. So as far as instrumentalism is concerned, over a century's worth of attacks on deductivism in legal reasoning means that it has also become hard to say with confidence that particular configurations of international law are or should aspire to be derived from broad commitments to certain instrumental goals, say market efficiency or social equity. It is likewise difficult to say with confidence that the use of any particular technology for international legal purposes will serve any such instrumental goal. Instrumental assessments of legal phenomena depend on a kind of reverse deduction, whereby an end is hypothesized and the expectation of law servicing that end is deduced from this hypothesis. So if we expect or want international law to become progressively more fair or efficient or whatever, then we deduce from that goal a standard for evaluating the law. And just as it has become to seem unreliable to reason from basic principles in a classical deductive mode, so the kind of reverse deduction involved in interpreting international law as a direct and reliable instrument of this or that kind of rulership, whether conservative, liberal, technocratic, social democratic, or some other kind, is problematic. The kinds of contradictions and ambiguities that have led many legal scholars to see policy making or politics everywhere at work in lawyers' decision making have also punched holes in these instrumental lines of analysis and prediction. It may be true that this or that provision of a trade and investment agreement is designed to benefit pharmaceutical patent holders, for instance, but there still remains a great deal of uncertainty as to whether and how it might do so in any particular instance of conflict or claim. And the text of the trade and investment agreement in question is almost certain to express divergent political commitments upon closer analysis, not just a singular logic servicing market elites. So the first problem for facing instrumental analysis of international legal phenomena, including digital humanitarianism, is the unreliability of deduction. A second problem with instrumentalism is that it is especially ineffective, I would argue, as a way of grappling with contemporary manifestations and outgrowths of neoliberalism. That is because of neoliberalism's embrace of contingency and reflexivity. And this is something that I've written about in terms of the prevalence of prototyping in international humanitarian and development work. Over the past few decades, more and more professional practice in these domains and elsewhere seems to involve finding tolerable yet explicitly provisional solutions to prevailing problems. For a great many people, of course, actual daily problem solving mostly takes the form of surviving. That is, devoting immense skills of ingenuity, regulatory know-how, and political energy to barely getting by, getting more or less enough to eat, to stay warm, and so on. For others, for whom getting fed and clothed is not such a pressing or immediate concern, international humanitarian work is increasingly undertaken as a patchwork of prototypes. That is, many people spend their days producing policy or institutional design blueprints that are presented as preliminary or subject to revision upon further receipt of further input or feedback. Now, of course, there's still a lot of long-term planning that doesn't take this form, but nonetheless, an awful lot of work in the international humanitarian field now takes the form of prototyping of one kind or another, including generating technological prototypes. And this turn to prototyping represents an intensification of dynamics that have been ascendant for some time, whereby progress has come to depend on the embrace of contingency. Marx foreshadowed this in the Communist Manifesto when he wrote that, quote, constant revolutionizing of production, uninterrupted disturbance of all social conditions, everlasting uncertainty and agitation distinguish the bourgeois epoch from all earlier ones. Since Marx's time, this orientation towards constant disturbance and reassessment has been compounded through first generalization of the imperative across all areas of life, of allocating scarce resources to determinate ends, that is, framing all areas of life in those terms, and second, encouraging people at every scale to approach relations competitively and entrepreneurially in pursuit of resources optimal allocation. And competition and entrepreneurship demand that claims be laid to constant revolutionizing, and the prevalence of prototyping is one manifestation of that orientation. So let me offer a concrete example, a prototype developed for international governance, namely the USAID funded Happy Fish, Happy People mobile application developed to capture and analyse real-time data in the Solomon Islands and surrounding waters of the Western Pacific. Now, the idea of this app was that it was designed to enable fishing communities and local fish market vendors to input data on fish catch size, species, and price for analysis and reporting via a customised platform. The stated purpose of the app was to aid fish stock monitoring, support compliance with catch limits and other environmental regulations, and ultimately improve food security with a view to realisation of the SDGs, especially SDG 2. Now, prototypes such as this prove quite hard to subject to traditional forms of instrumental analysis. The ends that the Happy Fish, Happy People app is designed to serve seem fairly clear, albeit multiple. Yet because the app is presented as a prototype subject to endless tinkering, any shortfall in the app's service of its stated ends is not likely to lead to the program's abandonment or root and branch redesign. Rather, criticism or shortfall is likely, that is, if it fails to deliver on the ends I just outlined, is likely to lead to a doubling down on the prototypes or optimization, or as often happens, the practice of turning to some successor innovation project that is similar in ethos and priorities. Conventional instrumental analysis seems to glance off the surface of this kind of international legal endeavour rather than to land and potentially alter the course of that work. I'll tell you what happened to this app a little bit later. Now, it is, of course, still possible to diagnose prototyping overall as a practice serving certain ends and to critique it on that basis. One might say, for example, that the very practice of prototyping in this or another mode serves the instrumental ends of capital or otherwise other prevailing forms of global power by deflecting criticism of prototypes' political substance and enrolling people in their continued optimization. Nonetheless, such an instrumental approach seems out of step with the way that much international legal work is experienced by those doing it, because both the ends that a prototype is meant to serve and its means of serving them are always subject to consultation, reassessment, and redirection in light of feedback. And it seems important that there is that misalignment with the experience of the work, those doing the work. So the second problem facing instrumental analysis of international legal phenomena is the proliferation of prototyping and prototypes that are hard to subject to instrumental evaluation. So That was a very long-winded entree to what I'm actually going to talk about today. I'm going to describe to you some ways in which international organisations, some additional ways beyond this example, in which international organisations, national governments, corporations and NGOs are integrating digital technology, data science and artificial intelligence into international humanitarian work, with the work of prototyping featuring prominently, as you'll see. But I'm not going to offer an instrumentalist take on this phenomenon. Instead, I'm going to try to leverage this incursion of the digital into the international humanitarian field to persuade you that the system of international law, such as it is broken. And I'm going to describe some instances of others leveraging this break in a moment as well. The social ontology that I'm putting forward, in contrast to instrumental rationality, is one of polysemy, misalignment, and struggle. Now, when I say that international law is broken, I do not mean that international law is ineffective or has failed. What I mean is that the incursion of the digital into international humanitarian work is both expressive and productive of a break, what might be termed non-scientifically speaking an epistemological break in international governance arrangements and practices. And in using those terms, you will recognise I'm borrowing from Althusser's transformative borrowing from Bachelard via the renderings of the term by Foucault, Balabar and others, a lineage that I'm not going to retrace here. Recourse to digital technology, data science and AI in the humanitarian field is not just giving international legal professionals access to new data, new knowledge and new analytical capacity. It is reorganising the very possibility of their knowing. It is changing the conditions of what is and can be known in the humanitarian field. There are still many continuities apparent in this work with what has come before and what has been done before, both where digital technology has been adopted and in the many domains of humanitarian work where it hasn't. As I mentioned, this is patchy and uneven terrain. But it is nevertheless possible to discern a break in the way that digital technology both combines with and calls into question certain analog logics characteristic of law and legal institutions, including in the humanitarian field. And with attention to that break, even insistence on that break, it becomes possible to say that international law is or can be something other than a continuous evolution from or inevitable cyclical reaction to what has come before. So I want to smuggle into this most unlikely of terrain, that is, amid highly technocratic, often plutocratic practices of data collection and analysis in international humanitarian work, a sense of emergent, collective, creative potential. So we've arrived finally, I hear you mutter, at the nub of the argument that I'm going to make today. It's not an argument about international law being made categorically worse by the practice of governments and international organisations having growing recourse to digital technology in humanitarian work, but it's also not an argument about international law being made necessarily better by that tendency. I'm not wholly pessimistic about measures like the Happy Fish, Happy People app entrapping Solomon Islanders in some surveillance capitalism hellscape, but I'm also not at all boosterish about the cost-saving, gap-filling, democratically enhancing impacts of this kind of digital innovation. What I am arguing is that there is a structural cleavage manifesting in the practices of international governance, a cleavage between digital and analogue logics that is giving rise to quite profound challenges and aporias. The instability or indeterminacy that we came to discern in language over the course of the 20th century is manifest also in the material infrastructures, non-linguistic schemes, artifacts, and mundane practices of international legal work as these come to combine analog and digital logics. And the political implications of this cleavage are anything but fully resolved or foreclosed. The break between analog and digital apparent in the international humanitarian field is a mark of unfinished, unresolved legal and political change underway in the international domain, in which an awful lot is at stake. Now, before I move on, in case you're wondering what happened to happy fish, happy people, well, it's a little bit hard to tell. It seems that after much promotion around 2014 and 2015, including being named one of the grand prize winners of the USAID Science and Technology Pioneers Prize in 2014, the app may have fallen quietly into disuse. This tends to happen with quite a few innovations of this kind. But because they're only ever billed as prototypes, this does not necessarily register as cause to reconsider the overall trajectory of investment in this kind of project, which underscores what I was saying earlier about their immunity from substantive critique. So, besides the ill-fated Happy Fish, Happy People app, what kinds of evidence can be seen for national governments, international organisations, corporations and NGOs turning to digital technology in the humanitarian field, broadly understood? Doesn't most humanitarian work still involve fundamentally analogue work of trying to move people out of harm's way and delivering food, water, tents and medical supplies to wherever they end up without bothering with too many digital interfaces and applications? Certainly this is still the case. This is what is most pressing in Gaza and Sudan and elsewhere. Nonetheless, as I have already described, more or less every international organisation active in the humanitarian field and many of their national counterparts have programs, quite significant programs, aimed at deploying digital technology, data science and AI across the humanitarian field. And multinational corporations, as I've just said, are heavily invested in the so-called data for good and data for development initiatives that seek to use digital technology to optimise humanitarian work. So there's a limit to how much one can generalise about the combined effects of this kind of work across the board, since these effects are highly varied and frequently overdetermined. Nonetheless, I want to draw your attention to a differential relation that is axiomatic to these efforts. That is their entanglement of digital and analogue logics. And in using these terms, I'm borrowing from the 1970s work of Anthony Wilden, a social theorist of communication, among other things. Analogue logic, as you know, is the logic of a protractor, a ruler, a sundial, a mercury thermometer, a measuring cup, or an accelerator pedal, each of which operates on the basis of relations of relative position, volume, or flow rate. Analog logic is organised around continuous variables and proportions, such as intervals along a spectrum. According to analog logic, each constituent unit of analysis can, in principle, be divided into ever smaller units or nested into larger ones, without necessarily becoming useless or meaningless. Analog logic conceives of units of analysis in relation to one another and according to their resemblances and differences of scale and degree. Reasoning by analogy is one mode of analog logic in which lawyers frequently trade. Within law, legal residence is an example of a mostly analog concept, even though it leans heavily on the resident, non-resident binary. That is because residence is determined by assessing the relative strength and duration of different attachments to a particular jurisdiction or for specified legal purposes. A person or corporation's legal resident for tax purposes may obviously be not be equivalent to their residence for choice of law analysis or for determining states' rights of diplomatic protection. Residence is always relative and determined according to degrees of attachment and is therefore predominantly analog. Analog logic may be contrasted with digital logic, which works with the discrete, non-divisible units in binary relation, on and off, 1 and 0, something or nothing, absence or presence. Digital logic is discontinuous, and presupposes gaps between elements, which is why it's something additional to the mere use of the binary. Gaps that in digital circuitry are spanned by wires, gates, and latches. Digital significations are denotative and precise. They identify and delimit elements in ways opposable to all other elements. Digital logic is oriented towards either or events, as distinct from an analog concern with both and processes and more or less similarities. Legal work, of course, employs digital logic. Legal, non-legal, national legal classifications may take this form, although typically not with an insistence on the discrete, but mostly law and lawyers do not work with the discrete. Mostly lawyers, like me, talk, think, and work along an analog continuum, stretching from the less to the more. Question X is more a question of national law than international law. Decision Y is most likely legally compliant, assuming factors A, B, and C. These are the kinds of analog assessments that lawyers routinely make. So the digital innovation work in the international humanitarian field that I've been alluding to invariably combines aspects of both analog and digital logics. These logics are typically entangled in projects like the one that led to the creation of Happy Fish, Happy People. It's a text message-based app. So when fishermen and fisherwomen input data in the app using a mobile phone, that gets converted into binary code for transmission. But the outcomes of this the corresponding data's analysis are presented as analog graphs showing continuous wavy lines representing fish stocks. Yet this entanglement notwithstanding, digital logic looms large wherever digital information and computing technologies are deployed, even though those technologies depend on analog logic too. The analogy of the machine to the human implied in the Turing test is a classical example of the importance of analog logic for computing. And because modern legal orders most prevalent on the international legal plane are typically more analog heavy than digital heavy, the incursion of digital logic into international humanitarian work poses a profound challenge to the way that knowledge gets made, communicated, and analysed for international legal purposes. So to give you a sense of this cleavage, I want to take you to another example of an application developed by an international organisation to support humanitarian governance in the face of impending famine or food insecurity. And that is the Hunger Map Live website or dashboard. In 2018, to try to boost its efforts to monitor and address food insecurity around the globe, the World Food Programme entered into a partnership with the Alibaba Foundation. Now, the Alibaba Foundation is a private charitable foundation based in Hangzhou, China, established and funded by the Alibaba Group, which, as you know, is a multinational retail, e-commerce technology and investment company listed on the Hong Kong and New York stock exchanges. The stated aim of this Alibaba WFP partnership was to support efforts to achieve Sustainable Development Goal 2, the ending of hunger, achievement of food security, and promotion of sustainable agriculture. By tapping the quote, and I'm quoting from the surrounding press releases, the support and expertise of the Alibaba Group to help WFP become even more efficient and effective in its work, end quote. So that was established in 2018, and then in 2019, the WFP's Executive Director, David Beasley, and Eric Jing of the Alibaba Group announced the creation of a new monitoring program called Hunger Map Live, saying Hunger Map Live monitors food security in more than 90 countries and issues predictions for places where data is limited. So as I said, it's essentially an online dashboard that displays a composite of data relating to food insecurity, weather, population size, conflict, hazards, nutrition information, and macroeconomic data. It's a screenshot from it here. Its main feature, as in this screenshot, is a map on which the prevalence of insufficient food intake at the first administrative level, so the province or state level, within any nation state depicted, is visualised through a colour scheme of greens, yellows, and oranges and reds. And population density is signified through brightness. When a user places a cursor over a particular administrative unit, two scores appear, one indicating the prevalence of people with insufficient food consumption, and one signalling the prevalence of people with a crisis or above crisis rating on what's known as the Reduced Coping Strategy Index. Bear with me, I'm going to talk a little bit about the technicalities before I come back to the implications of this kind of tool being utilised. So the first of these indicators measures dietary diversity and the frequency of consumption of different kinds of foods, and the second is an experience-based indicator measuring the extent to which households have, over the prior 7 days, adopted certain strategies to cope with not having enough food or enough money to buy food. So they're both proxy indicators of hunger. The stated aim of scoring places in this way on the Hunger Map Live map is to help users, which the WFP expects to include WFP staff, key decision makers, and the broader humanitarian community, to assess, monitor, predict, and respond to hunger in near real time. These two scores on which the users of Hunger Map Live are invited to focus are calculated using one of two methods. For one subset of nation states depicted, they're calculated from survey data, gathered by using digital technology to replicate traditional in-person survey methods. So the WFP randomly dials people in selected countries and uses computer-assisted telephone interviewing to collect data on demographic variables, food consumption, coping strategies, and access to food, market, and health services. And this data is collected on a rolling basis, but processed and updated on Hunger Map Live daily. For another subset of nation states, however, in which ongoing data collection of this kind is not conducted, these scores are outputs of a machine learning process. The WFP uses an extreme gradient boosting algorithm, which is an ensemble of regression trees for those who know about this stuff, and 14 years worth of training data from 63 countries to develop models that generate estimates of the prevalence of food insecurity in states where no survey data is available or only patchy or outdated survey data are available. And the inputs for these models are drawn from a range of government sources, international organisations reporting, and commercial sources. So, Hunger Map Live foregrounds analogue logic insofar as it assesses sub-state units' placement in ordinal rankings of crisis, employing cardinal measures of the quantities of food consumed. Both the ordinal and cardinal aspects of this analysis are relative more or less assessments. In other words, Hunger Map Live measures food security in an analogue way. At the same time, Hunger Map Live translates these assessments into discrete units with well-defined boundaries, that is, into digital terms. At any one time, a given place shown on the Hunger Map Live map is shown in one of 6 colours between dark green and red. And these are, of course, more or less indicators of the degree of food insecurity. In that sense, they're analogue, but they're premised on a calculation of discrete scores for the entirety of each province or state, enabling it to be distinguished from or opposed to other provinces or states' degree of hunger. A place that is shaded dark green is a not red place. It is a non-hungry place, even though there may be hungry people within it. And these colours are expressions of embedded binary code that the Hunger Map Live interface is configured to execute. Their reference are further layers of binary code. So those who are experiencing hunger are apparent only as presupposed yet remote drivers of colour change on this interface, from cool tones to a more alarming orange or red. Like all dashboards, the primary emphasis of the Hunger Map Live interface is on those who may be alerted and potentially moved to action by the interface's code-driven colour change. not those whose suffering is implied in it. The ascendance of digital logic that is apparent in Hunger Map Live breaks with traditional analog registers of doing and evaluating humanitarian work. Unlike many humanitarian communications and evaluations in the past, Hunger Map Live does not depict hungry people and places on a journey or trajectory towards improvement over the longer term or decline. Nor is this interface attuned to tracking how a slow onset humanitarian emergency emerges gradually over time, although the WFP is very attentive to that. No effort is made to elicit judgments of the deservingness of those experiencing hunger, to evoke pathos, or to engender experiences of intimacy at a distance, all of which are modes of relation on which calls to action in the humanitarian field have so often depended. The discreetly parcelled present and the challenge of making that present more data-rich takes precedence when hunger is so visualised, and all those other registers of relation fall into the background. Hunger is at least potentially a state that switches from off to on, from green to red on a moment-by-moment basis. This sense of food insecurity or hunger as an emergency in constant flux, requiring incessant vigilance, is reinforced by the ever-changing country-specific news feed that appears in the lower corner of the screen after one selects a particular nation state from those listed on the drop-down menu. The digital data assembled by Hunger Map Live does, of course, include historical data, but the continuously updating interface does not draw attention to the difference in timescales associated with different forms of data. Data on different geographical areas is updated at different intervals, as you would expect. Phone survey data is collected on a rolling basis, but spread over 28 or 30 calendar days or over a 3-month period. And daily updates are generated on that basis with a slight time lag of 2 to 4 days to ensure data quality. Meanwhile, machine learning inputs are reported, so the inputs that feed the algorithm for the purposes of prediction where no survey data is available, those are reported at very different intervals, some weekly, some quarterly, some annually. Nonetheless, Hunger Map Live does not make available or distinguish between these temporal scales. Their edges are smoothed and their junctions made seamless. They are all made to speak to the near real time on which the interface places emphasis. So you may be wondering, am I saying, is this a good thing or a bad thing? Isn't it a good thing to have more timely data on hunger accessible to more people so that those committed to working on the problem can be more effective perhaps, and those unaware of its prevalence can be alerted? Maybe one could imagine this being used for various sorts of lobbying and fundraising efforts and other purposes. But the implication that the Hunger Map Live interface puts forward is that bad things happen in the world when they are hidden from people, that what we lack most is information, and that good things are more likely to happen when information about bad things is shared more widely. Susan Marks has called this the myth of the dangerous dark. Hunger Map Live presumes this to be the case for hunger, or suggests that it is. Yet the UN Special Rapporteur on the Right to Food, Michael Fakhri, has argued otherwise. Climate change, conflict, and trade law and policy, these are, he tells us, all significant drivers of hunger, and these are not matters about which we lack data. So one of the reservations that might be raised about Hunger Map Live is that it turns hunger into an informational problem of an either-or character, and presumes a direct line from information to agency. If we know, we can act, it seems to tell us. And in so doing, it strips away any social ontology of struggle and any sense that law and policy may operate as countervailing forces in the struggle for more equitable distribution of food. Still, you might wonder why I'm making so much of the technical properties of this one interface, which is, after all, just one prototype that may not actually be very widely used or relied upon. It's hard to tell. This ascendance of the digital in decision-making tools such as HungerMap Live matters to international law and politics, I would argue, for at least two reasons. First, it matters because some of the usual routes that legal analysis travels down on the international plane are scrambled or problematized by digital logic. It becomes difficult to compare the effect of spending on a HungerMap Live to, say, spending on the Indian NGO Akshaya Patra's midday meal scheme in government-funded schools, because they're so clearly discontinuous in how they conceive of hunger. The midday meal scheme frames hunger as inextricably bound up in family and community relationships and shaped by institutions of governance and education. HungerMap Live casts hunger as a meta-level informational deficiency with no clearly discernible relationship to law or policy settings in the jurisdictions depicted. You'll recall that I said earlier that digital logic presupposes gaps between elements. In line with this logic, HungerMap Live does not address its relation to any other measures or efforts surrounding the production or distribution of food. In the face of external critique, that is, critiques from outside the system that question its values and priorities, the tendencies surrounding interfaces such as HungerMap Live is to downplay their transformative effects. This is just a prototype, just a decision support tool, just a matter of minimally optimizing what we're trying to do already, one might say. Human decision makers are still calling the shots. That may be true, but an awful lot of investment of energy, money, and other resources are flowing into these kinds of initiatives and therefore away from others. Also, when we represent hunger as a red-green condition in a state of data-driven flux, we change what we understand hunger to be or entail. It is not, for instance, an ecological relation, or it is contingent on the background distribution of economic and legal privileges and disentitlements. Digitalizing hunger transforms how hunger is problematized and hence how people and governments are invited to act on it and how it is readied for action. Meanwhile, many internal critiques, that is, critiques that take the value and necessity and utility of measures such as HungerMap Live as a given and try to get them to live up to their promise, are also derailed by the predominance of digital logic. Interfaces such as HungerMap Live are highly self-referential and premised on the layering of data about data about data, working assumption on working assumption. The normative commitments embedded in them become very difficult to extract from such frictionless, user-friendly interfaces. As such, they tend to absorb or deflect a lot of possibilities for internal critique, much as they do possibilities for external critique. HungerMap Live's developers have been relatively transparent about the methodologies that they employ, far more than many others, comparable interfaces. They've made available lots of information under their methodology and glossary tabs, for instance. But that approach to counteracting critique, worries about bias, for instance, only enrolls would-be critics more in data generative engagement with the interface. If someone is worried about bias or occlusion, the answer is always to go further and deeper into the interface at work, and therefore to imbibe its predominant logic even more. So second, the ascendance of the digital matters because it suggests that much analysis of the international legal domain may have taken its eye off the ball of how profound structural change takes place on this plane. Scholars and policymakers alike tend to look to certain sites when we try to understand how global change has happened in the past and how it might occur in the future. National legislatures, regional parliaments, multilateral treaty-making processes, national and international courts, and regulatory agencies. These are the kinds of places that we typically turn to when trying to analyse how things came to be the way they are on the international legal plane and how they might yet be otherwise. However, what becomes apparent in the fracturing of humanitarian work along digital and analogue lines, and the aporias that emerge from that fracture, is that international legal order is already otherwise than how we commonly describe it. In practice, it already diverges from many of the maps and rubrics with which courts, parliaments, and regulators typically work. Systemic structural change is quite frequently brought about through practices other than institutional design, official law reform, or authoritative policy deliberation, these examples suggest. Much of it gets enacted in quite mundane, seemingly technical shifts in how the world gets rallied and readied for action. We can see this in the change being wrought by the rise of digital logic in the humanitarian field. What is roused in this shift is a sense of, is a sense of imminent externality, incalculable, incontainable, incomputable properties of the here and now that speak to the propensity of the world to be other than it appears to be. And given all that is unjust and unbearable about the world as it appears to be, this imminent externality is something worth activating in how we think and work on the international legal plane. So what then could be done with this and in this sense of imminent externality, you might wonder? What good is it to anyone? Well, its value is far from assured. I'm inclined to think, though, that this break may be leveraged strategically, including by those on whom international legal work bears most harshly. To give you just one sense of how this may be done, let me conclude with a story of the digital mapping work of the Guarani people of the Amazonian region of eastern Ecuador, working in collaboration with Alianza Sebo, an alliance of 4 indigenous nations, the Guarani and 3 others, and a San Francisco-based not-for-profit called Digital Democracy. In 2018 to 2019, the Guarani sued the Ecuadorian state in the province of Pastaza, objecting to the state's failure properly to consult before proceeding to commercialize rights to extract oil resources in the territory of the Guarani communities. They argued that this was contrary to the Ecuadorian constitution and international treaty and customary law. Among the evidence submitted in support of these claims was the output of a digital community mapping initiative carried out over 3 years. 20 Guarani communities used Mapeo, a free open source collaborative mapping application developed by Digital Democracy, to map large tracts of Guarani territory using categories and descriptors in Watero, the Guarani language, and icons designed by community members. The result was a rich digitized cartographic record of ancestral knowledge, traditional medicine, sacred and culturally significant sites, symbols, livelihoods, and toponymy, as well as non-human beings inhabited Guarani territory, designed to aid defence of their right to consultation prior to any commercial exploitation of that territory. And they won. The Tribunal of Pastaza found a violation of Guarani rights and granted them primarily procedural relief, a ruling later affirmed by the Provincial Court of Pastaza and the Constitutional Court of Ecuador. And in that ruling, specific mention was made of the Guarani's fundamental and special relationships to territory evidenced by these digital maps. Here is an image of one of the maps in question. Now, one could say a lot about the limits of this kind of free, prior and informed consent type proceedings. I'm well aware of the extensive critiques of that. But what the Guarani were nevertheless leveraging in this instance was exactly the analog digital disjunction to which I've been drawing attention. It was precisely the indifference of digital signals to pre-existing states, as well as digital technology's accommodation of discrete multi-user inputs, that enabled the Guarani and their allies to activate multiple attachments to and meanings of territory that would otherwise have been illegible to the court. They were able to leverage these, especially against more encompassing predominantly analog depictions of territorial ownership and rights of extraction. Digital mapping enabled the switching on of multiple affiliations to substantiate claims that could be made recognisable under applicable laws. Now, this was, of course, only one small element in a long and ongoing struggle that is ongoing to this day. There were, at the time, intergenerational and other conflicts around the mapping process, and the whole exercise was conditioned by the need to solicit state recognition in the first place and by the limits of procedural rights, such as consultation rights. Nevertheless, it is indicative of possibilities with which the epistemological break that digital technology introduces to the international legal field could be invested, even as we remain mindful of the perils with which it is also associated. Now, I haven't said a great deal about those perils, but let me assure you that the book, #help, in which I developed the argument that I presented to you today, is clear-eyed about them. After all, the recourse to digital technology in the international humanitarian field has not come out of nowhere. It is bound up with decades of public-private partnership, outsourcing, public austerity, and the pressure on international organisations to demonstrate their relevance and responsiveness after a series of high-profile scandals and abuses of power. And tech companies' movement into this space is part and parcel of their efforts to secure social licence for relentless data extraction and monetisation, and to enrol new classes and generations of users into various forms of what might be described as tech dependency, often with an embedded racialising cast. So I could, of course, have spent the entirety of today's lecture restating these observations and the compound inequities to which they give rise. But what I've sought to do here and in the book instead is to insist that this present and this future are not so foreclosed. What Weber famously called the iron cage of formal rationalization, whether one identifies that today with techno-capitalism, techno-determinism, innovationism, algorithmic calculability or whatever, is cracked. There are fissures and snags all the way through it, including in its law and policy infrastructures and practices. And these are open to collective counter-engagement wherever digital technology is being deployed to varying degrees, including in the international legal field. That is what I mean when I say that international law is already otherwise. I look forward to the discussion. Any questions? And thanks for listening.